just a smattering of cases and events. The Eighth Circuit has heard oral arguments in a college's deregistration of a Christian student group case. This is the InterVarsity Christian Fellowship USA against University of Iowa case. I believe Beckett has been involved in some way there. In that case, an Iowa federal district court held that the University of Iowa and 3 of its administrators violated the free speech and free exercise rights of a Christian student organization when it revoked its registered student organization status. And these kinds of cases are coming up quite regularly and are being litigated. I think that the plaintiffs in a lot of these cases are actually having some pretty good success. So the district court held that the university's action was taken because of the InterVarsity Christian Fellowship required its leaders to affirm the Christian group's statement of faith, which is typically where this occurs. You have to have you have to sign a statement of faith in order to be within the leadership of these groups, and that is often in contrary to the diversity and inclusion policies of student clubs on these campuses. And then the issue arises of whether that's a violation of free speech. So I think it's going to be interesting to watch these kinds of cases. Like I said, they're popping up all over the place.
Alexander, do you know
another one
whether
that's
it's typical? Do you know whether it's typical for those statements of affirmation of faith to exclude Latter-day Saints?
They can by implication. So many of those are Trinitarian affirmations of faith, and you would have to affirm those in order to participate. Somewhat similar to Christian Legal Society, for example, which has a Trinitarian statement of faith, and some of our friends have sought to participate in Christian Legal Society and have been politely declined. Although I think in one case, a friend of mine was offered a sort of adjunct membership or something like that. So another area that I think is a bit interesting, not one that I have followed in the past, but there are some Native American Apache leaders who have sued to prevent the Forest Service from transferring a religious site, this is federally owned property, to a mineral company, a mining company, which would likely destroy that site as a sacred site. The case involves both free exercise and RFRA claims, and raises an issue that we don't talk about much. It's not much of a culture war issue that gets a lot of press. But the question is, what free exercise and RFRA rights might exist with respect to federal property and the use and disposition of federal property. That comes up periodically. So that'll be one to take a look at. It's been filed in the Arizona Federal District Court. Ministerial exception, Department of Labor in one of the final Trump era rulings or opinion letters concluded that the ministerial exception doctrine can create an exemption to the Fair Labor Standards Act requirements. And in that context, the letter concluded that a private religious daycare and preschool may pay its teachers on a salary basis that would not otherwise conform to the wage and hour requirements of the FLSA. If the teachers qualify as ministers, this raises a really important question. How far is the ministerial exception going to go? And what I always advise religious groups is not to try to push the ministerial exception too far out of its natural boundaries. It's so important, in the space that it needs to inhabit, with respect to the hiring and termination of ministers. But trying to extend it too far really risks having it trimmed back. But that was the Trump administration kind of one of their final memos and things that was released. Another one that is similar or kind of in that vein, the Department of Education ruled that the Bostock decision does not apply to Title IX. And this was a memo that they released on January 8th, basically saying that the Bostock decision was very focused, and that's the decision that held that the term sex under Title VII includes sexual orientation and gender identity. And the court in that decision, as you'll recall, was focused on a decision based on sexual orientation or gender identity not being able to be made without focusing on sex, including without focusing on biological sex. That was kind of the basis of this. And the Department of Education really said that rationale doesn't alter Title IX and doesn't turn Title IX, which governs, of course, sex discrimination in the context of higher education. It doesn't turn that into an LGBT kind of rights, bill in that context, or rights legislation. What was interesting is that on the first day of the Biden presidency, President Biden signed an executive order that essentially undid that memo and a series of other policies related to it, and ruled that sex will be construed to include sexual orientation and gender identity for purposes of Title IX, and frankly, for purposes probably of most administrative decisions. So that, of course, will trigger some really interesting questions about the exemption under Title IX, which protects religious schools and so forth. So the battles in this area continue. That's it. That was less than 5 minutes, I think.
Well done. Thank you very much. Thank you for taking the time to do it with all that you have going on. Appreciate it. John, on the on the Native American sites question, in case anyone is interested, Stephanie Barclay has an interesting article coming out with Michael N. Steele in the Harvard Law Review about sacred sites like that. So if any of you are interested in that, you might take a look at it. Basically, they argue that these sacred Indian sites and the way they're controlled by the federal government should be analogized to the control that the government has over prisoners, and therefore any burden on religious exercise should face heightened scrutiny the same way that a burden on religious prisoners exercise faces heightened scrutiny. It's an interesting article, and we'll certainly get more profile because it's in the Harvard Law Review.